What's up, everyone? Today, let's go inside a heated Judiciary Committee hearing where Senator John Kennedy pressed a nominee on textualism, one of law's toughest questions. The back and forth was sharp, revealing, and honestly, pretty entertaining. Picture this. It's June 5th, 2019. Senator Kennedy asks the nominee, "Are you a textualist?" The nominee hesitates, saying he focuses on the text. Kennedy presses, "How ambiguous must the law be to look beyond words?" That's where the clash begins.
Thank you, Mr. Chairman. Judge? Are you a textualist?
Yeah, I don't label myself, but yeah, I definitely look at the text first and foremost to divine the meaning of a statute.
My understanding of is that one definition of a textualist is that you must take a statute. You look at the statute. And if it's unambiguous, you apply the words. Is that right?
That's exactly how I understand it, Senator.
Okay.
Kennedy pushes the point hard. He asks, is it 51% ambiguous, 67, or must the words be 100% unclear before you dig deeper? The nominee says judges use traditional tools and only look further if those are fully exhausted. Kennedy wants an exact standard, and the exchange gets intense.
How unambiguous? Well, let me put it another. How ambiguous do the words have to be in order for you to look behind the words? Is it 51% ambiguous, or 100%, or 67%?
Senator, that's an absolutely great question. And we see that manifest itself with Chevron deference when it talks about ambiguous statutes when you go from step 1 to step 2, if it's ambiguous when you go. And that's actually a somewhat hard question to answer, because sometimes different judges have different commitments in terms of degree of ambiguity. My view is this: we have a rich tradition of looking at the text, the structure, and applying canons of construction to statutes. I wouldn't look beyond those until all of those traditional tools have been exhausted.
Well, let's suppose words have different meanings to different people. Let's suppose that to you, the statute that Congress, for example, has passed is clearly unambiguous. Would you never look behind the words to see why Congress passed the statute if the words were clearly unambiguous to you?
If I believed that they were clearly unambiguous, I would not take any initiative to do that. Now, okay. I assume the parties would brief Congress's purpose, and I'd read their briefs.
But you got to ignore that if you're purely a textualist. So I'm not saying you're wrong. I'm just trying to understand how you think.
Yeah.
Here's where Kennedy really drives the issue home. He asks, what if Congress says all federal printing must go to the highest bidder? But what if the government could save $50 billion by printing in-house? Kennedy argues the legislative history shows Congress meant private sector bids, not in-house. It's Kennedy's way of showing how pure textualism can clash with common sense.
Let's suppose Congress passed a law, and the law said all printing by the federal government must be awarded to the highest bidder. All printing by the federal government must be awarded to the highest bidder. That's pretty clear. Let's suppose that GAO did a study, and they found that if we did our printing in-house, we could save $50 billion a year. Could we do our printing in-house?
As I read that statute, no, I don't think that's possible. I might add that my wife is an alum of the GAO, and she's very familiar with those sorts of studies.
Yeah, they did good work. Well, suppose you looked at the legislative history and it was clear that the Congress was referring to instances where the printing was offered to the private sector to bid on. And that the problem they were trying to solve is that some agencies were not awarding the bids when they were given to an outside party to the lowest bidder.
Well,
Wouldn't it be nonsensical not to look at the policy?
The nominee argues that sticking to the text keeps Congress accountable. If lawmakers meant something else, they can always change the statute. Kennedy pushes back. If history makes it obvious, why ignore it? That's the tension. Should judges stick to the words or consider context in history?
well, Senator, one of the problems that happens when a judicial body relies on something other than the ambiguous text of a statute is it makes it harder for Congress to make corrective action. If Congress passes a statute that says all printing and a judge says that doesn't mean all printing, I assume that you and your colleagues would say, what doesn't this judge understand? It said all printing.
No, we wouldn't, because if you looked at the legislative history, you would see that we weren't saying government couldn't do its own printing. We were saying if you're going to give it to the private sector, you can't give somebody a brother-in-law deal.
And what that would mean...
And all you got to do is like go to the committee report and look at the floor debate. And there it is, big as Dallas.
Well, I think that there's two responses I have to that. One, text is usually easier to decipher than legislative history. And
True.
Two, I think that...
Sometimes it's more ambiguous.
Usually, it tends to be, I think is the direction that I'm going. But I think, too, by judges sticking to the text, that allows for Congress to be very, very receptive and very, very responsive and say, that's not what we meant. And you can change that very quickly through the political process that is politically accountable. And I think that that makes a lot of sense. And I know that America and Congress has a very rich tradition of doing so. And as
being responsive, Congress?
Yes, I think so.
You're being kind. I'm out of time. Thank you, Mr. Chairman.
This exchange isn't just about one hearing. It's about two competing views of law. One side says follow the text. The other says context, history, and purpose matter. Kennedy's sharp questioning showed how tricky that choice is. Senator Kennedy did what he does best, cut through legal theory with blunt, sometimes funny, but always revealing questions. The nominee defended textualism, but Kennedy exposed its limits. This debate shapes every major court decision today. Like, share, and subscribe for more deep dives into moments that matter.